Building.
Back in the building, y'all. Y'all know what it is. It's the dynamic duo. You know what I'm saying? Back
No, no,
again.
no, 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 no,
You
no, no.
know. Yeah, we about to get it in, y'all. We got a great show tonight.
No, no, no,
I just want y'all to know that this is a great show, man. It's for all the Moors out there, man. This is a great show because this is one of the most important. These are like part of the most important legal issues that the Moors are having is dealing with this treaty of peace and friendship. So we gonna get into that tonight, man. But before we get into that, um, yo, check out my books. We talking about the treaty right now. Yo, go check out my book on the Moorish Treaties. Okay, y'all can get the book and get all the books that I got by Bandele El. I got a variety of books on Amazon, so please go check them out. Right. Um, so with that being said, tonight, tonight we gonna get into um, we're gonna get to some of these treaties tonight, man. Because, like I said, man, we're gonna have case law. We're gonna look at some case law and look at what they did and why it's not working. Why are why is using a treaty not working in court? Anybody come in the building if they've had some success using the treaty of peace and friendship in court, please chime in. Get in the comments. Let us know your experience. But what we're going to do is show you exactly what we're seeing in court and why it's not working. We're also going to look at what is the Moroccan Empire. Does the Moroccan Empire does it still exist? How is the treaty used in relation to the United States today? And does Morocco still have any authority over the treaty? Okay, so all right, we're gonna get into it today, man. We're gonna get into the nook of the cranny in this,
Before
man.
we get started, can we introduce some of my books too? Also, Chief.
Yes, sir. Brother,
Let's
we
get.
got Brother King L Bay in the building. Yo, once
Yes,
again,
sir.
King L
Yeah,
Bay is in the building, man. It's been
I
a
got.
long time since
Yeah.
we did something.
So, I got the book out. Still got the child support book that you can get. How to stop child support. The must child support manual. Then we
Okay,
coming
after
out
you
with
got
it
the Kindle, you got one on
now.
Kindle too, though.
Yeah, so now we coming out with the Must Morris Blueprint to Redemption series, and the first one is talking about the doctrine of lost
Gotcha.
sovereignty. So we're gonna get into the Morris Blueprint. So how what do Moors need to do? And this is the first key step of understanding, you know, the doctrine of lost sovereignty. So just want to put that out there. We're gonna get back to this, so you could go
Hey,
there.
I see it's on Kindle though, so y'all can, yeah, you can get it on Kindle. Right.
Yeah,
Yep.
yeah, you can get it on Kindle.
Yep. So
So
so that's what's
I'm
up, bro. Y'all need to check that Cop them books, man. Cop them books on Amazon. And
it,
please, if you're in the building, please like the video and please subscribe to the channel. Okay. We're trying to do this. We're
please
gonna drop
subscribe.
some jewels. Look. We're gonna drop these jewels, right? If you like what we're talking about, you need to subscribe. And y'all need to send this to somebody else. All right. So let's get into it, man. What we talking about, man? Me and King been going back and forth. That's why we got to do this show because we've been going back and forth about this treaty, and we haven't seen a lot of success with people using the treaty in court. So we just want to show y'all what's going on in court, okay, and what they're doing. And we also, like we said, we want to look at what's going on with Morocco. Is Morocco looked at in the same way that it was looked at back in 1781 or 1836? Does the United States look at them in the same way? So we're gonna look at all that tonight, so that we can, at the end of the night, we're gonna have a better understanding of how the treaty works. Okay, so um, what you want to get into? You want to get into the what like the court case?
But wherever you want to start, um, we can get into a lot of different aspects. There's so many things that we need to cover. There's so much ground, so it don't matter where we start because there's a lot of ground to cover on this topic.
All right, I got you. So what we gonna do is, like we said, we're gonna get into this, man, because we got to keep y'all interest. Y'all, everybody got ADHD up out here. You ready to jump off. What we gonna do is let's look at the case law that sparked this off. Right, this week we got to looking at the case Houston versus Houston. Right, and I'm gonna tell y'all, man, this case right here is it's it's crazy. Okay, so. Um, let's jump into it. I guess I'll read it since I got it up, man, and you can just stop me when you're ready to say something, okay?
All right.
So we got it up. United States District Judge, blah blah blah. Now this right
You
here. So we
gotta,
getting into it, right? Look,
right. Okay.
go ahead.
So just
Oh,
saying,
okay,
people
okay.
need to understand what "su sponte" mean when you get to some of these Latin terms. They need to understand
Oh
what
yeah,
it,
I mean,
so you can
intervene,
pull it
man.
up.
Yeah,
So
intervene
I'm
whenever.
ready to pull it up.
Okay. So I mean, what you want to talk about the sua sponte,
Now, I
dismissing the case and denying the plaintiff's request to seal the pleadings. So this case, this particular motion is part of a bigger, case
mean,
that's going on. Okay, so let's look at what the plaintiff. It says the plaintiff filed a pro se complaint against more than a dozen defendants. Okay, after reviewing the complaint, the court has determined that there is no subject matter jurisdiction and will therefore dismiss the complaint sua sponte. So go ahead. What does sua sponte mean? Like if you know off the top or
well, "su sponte" is like where the court dismiss it on their own will, on their own action, because there is no controversy at at in front of the court. They don't. It's like what you saying. They don't recognize because they're not a court of competent jurisdiction. Because whatever he was speaking about, they was like, we don't understand what you're saying. So
right,
dismiss this because it's frivolous and we don't have whatever you saying. We don't have subject matter jurisdiction over it, and it don't apply here. You can't apply it here in this court. We don't know what you ask. So we just gonna dismiss it. You brought a claim in which we is incoherent.
I got you. I got you. So all right. So now we're looking at the background, right?
Right.
So the background says that the plaintiff sued. Now this is now, hey, you got to help me understand this, though, y'all. Look, check this out. The plaintiff sued his own estate and a host of private individuals and public officials. So now, okay, y'all, we talk about a brother who's a Moor. So this is what he's doing in court. He's suing his own estate and a host of other private individuals. Do you have anything to say about that, my brother? Before I move on, bro.
Okay. So he was suing his own estate.
Yeah,
He it don't even make sense because you can't sue your own estate. It's just like you can't sue yourself. You can't say, "Well, I'm gonna sue myself in court." So it can't be King L Bay versus King L Bay and not sue. And then I argue my position as a plaintiff. Then I go over there and argue my position as a defendant.
right. So
You
this right here is frivolous as hell
can
anyway.
sue the trustee, right, for
Right.
breach, but you can't sue the estate.
Got you. I got you. So among suing himself, I guess, right? Or his estate.
Right.
He says among public officials are attorney generals of the United States, of Michigan, and Illinois. The secretaries of state for the United States and Michigan, the governor of Michigan and Illinois, the secretaries of Treasury, Interior, and Homeland Security for the United States, a United States Army General, the director of the Illinois Department of Children and Family Services, and a supervisor at Lutheran Social Services of Illinois. All right, man. Look, man. I'm just look, Moors, my brothers, Islam, okay? But look, when you going in here to court, come on, what are we doing? What is this? What is this? Like, we go in there trying to sue everybody, right? And we trying to sue ourselves. I want y'all, whoever in the, let me go in the chat room, man, see if anybody in the chat room. I need y'all to answer what you think the hell was going on with that. Okay. Well, why y'all do that, man? Okay, so okay, from that aspect right there, I mean, do you need to go on? You want me to go on? You need something to say about that? You there? I can't even hear you, bro. Hold on, let me see.
Okay.
I
Now
might.
I put it on.
Oh shit. Yep.
Now then you muted me.
I
You
got
still
you.
got me muted.
I didn't mean to. Nah, you good. I hear you.
So the thing about
Go
what's
ahead.
going on here is he was just listing a slew of plaintiffs, but he had to specify the cause of action and the nature and how the injury occurred and how was they a state actor, and he had to apply the appropriate application. See, a lot of Moors don't know the application of what the law to trigger the jurisdiction to go into the proper venue. It's the application that you need to understand how the law works. So you got to apply the right application to get the right remedy. You see what I'm saying? So a lot of Moors don't understand. For example, if I go and I apply for something, then they have to explain to me why, if the government, why I didn't get it. They have to tell me what I need to do to qualify for these benefits. And that's a necessary component. When you go into court and you applying, asking the court to hear a matter, then you have to put everything under the proper context as it related to the application of law, and you have to show the facts that trigger that application and the remedy that goes with it. A lot of people just don't really know how to lay down the foundation to this, so they end up doing it. That's why I talk about motion pleading. It's always a motion affidavit in support of the motion with the exhibits that supports your findings as it relates to the position in law and the affidavit, because the affidavit is the facts, then the law is your memorandum, and the exhibit's going to support both. So you're going to have to understand how to reference everything, and a lot of people just don't. It's a skill. It's an art. I learned it from doing it over and over and over, being repetitive.
I got you, man. I got you. So when we look at the next paragraph, this is like just like I said, this is for us Moorish brothers. Look at what he's writing. He's saying that the meandering complaint contains several causes of action. The plaintiff first requested that the court issue a declaratory judgment that plaintiff is a private Moor, America's Aboriginal, Illinoisian national, and subject of the El Marak Sharifian Empire, but not a citizen of the United States for the District of Columbia, nor a citizen of the United States of America in Congress Assembly. So That's a lot, man. So, like, do you think when he wrote that, how far off was he? I mean, what? Let's talk about this. I think you are you there? You muted or what? Let me go back. Oh yeah, you muted. Okay, I didn't know you was gone. So
No, I was just getting something to drink. He
you
don't
good? So
understand.
what I was
You can tell he's all over the place. He is
so
first
where
of
do you
all,
think we went wrong right here? Yeah, go ahead, break it down. Cause
first of all,
that sound legit. That sound legit.
he's a he's a private Moor, American Aboriginal, Elise, Illinois
Illinois.
national, and subject of the Moroccan Empire.
Yeah,
So
Alma Rock Sharifian though. What's that? We gotta get
okay,
into that. Go ahead
so
though.
so this is the thing. He is commingling, and he don't understand the application in which he's. So he's saying that he's an American, right? Private
Yeah.
Moor American, meaning that he's a part of the United States. Then he turned around because he's an Illinoisian, and then he say he is a subject of the empire. So what are you? You American U.S. national? Are you a part of the United States of America, or is you do you have dual nationality? Is that what he's saying? He have dual citizenship in both the United of the Americas and under the Al Marak Sharif Empire? And where's that located? And where's the treaty associated with that? So
So so the Sharifian Empire, I think he's referring to um, the Moroccan Empire. So that's another term. But we need to look. We need to look at that. Um, at some point, right? I mean, while we talking, we can get to where we're going, but I think we need to look at that at some point in this
right.
discussion. Yeah. But go ahead. So are you saying like if you was to put this together, you wouldn't say that you're a private Moor, that you're not
No,
of America's Aboriginal,
no,
you wouldn't be an Illinoisian national?
no. That wasn't how I identify myself. I would identify myself as uh, ancient. I would identify myself as a treaty party, first of all, of ancient descendants of who have treaties with the United States, and I would identify doctrines that would like the doctrine of law sovereignty. That I'm still an heir, and I'm still sovereign in my capacity, and that the treaty, right, is a right of inheritance. So you got several doctrines. That's why I started with the doctrine of law sovereignty with this book to express how Moors have lost their sovereignty, but they're still they're see, this is what a lot of people think, that Moors lost their sovereignty and we haven't lost our sovereignty. A lot of people think government is just sovereign. No, the people give up their sovereignty to be to the government. They give it up. The government don't wake up. The people create the government. The government is a parliament of the people, right? So you might
I'm with
have so so you might have tribes, right? 7 different tribes. And then they say, well, we're gonna come under a confederation, yada yada yada. We're gonna create a constitution, and then we're gonna create a government for us, for seven tribes. And that government is what's going to help us stay peace, manage the peace between us. And then we're going to choose to elect delegates and everybody to assign to represent our interests and our rights. And then we're going to sign this treaty, and then we're going to do a lot of different things to allow us to reconcile our differences when it come down to any of our rights for contracts and property and all of these other things, family disputes.
Okay. Okay. So looking at looking at the second part, he says it says second, plaintiff requested that the court terminate any guardian or ward relation and return an estate to plaintiff. So then third, plaintiff sought relief against all liability of the estate as the implied equitable surety or secondary liability imposed upon him in all legal proceedings of a general military character. So, all right, I'm gonna stop there, man, because, like I said, he's saying a lot. What? First, he's saying that he wants to request that the court terminate any guardian or ward relation and return an estate to plaintiff. So, what is it that you think about there?
Um, Everything start with proof of claim. The way that he's referencing his complaint, he need to show equal protections under constitutional references or treaty. He just not identifying, and he just doing a lot of throwing a lot of statements around.
Okay. And so then
And,
this part right here, though, because he's talking about like all this relief against all liability of the estate as the implied equitable surety or secondary liability imposed upon him in any legal proceedings of a general military character. So I mean, like, I mean, we talk about the military and how everything is military related. Do you think that has anything to do with this, or I mean, like, what is this being said right here?
what he's trying to do is sue for his freedom. It sound like it sound like he in bondage, and he's trying to sue
Okay,
them for his freedom. And I don't. I mean, and everything is
you
done
see, but
voluntarily.
right, like it sound good, but it's frivolous, y'all. Like this, let me just keep it real. Like this shit is frivolous. Like I understand what he like. We understand that he's trying to convey that he has no liability, that he's but the fact that this is not how it go. This is not how it operate. This is why he got denied. So let's look further on where it says that fourth, the plaintiff requested equitable relief related to trespass upon your orator, inherited right to equal justice being rendered toward him concerning any dispute and exoneration of any of all liability and obligation imputed to plaintiff by defendants. I mean, like what? Like I get it, but what is? Come on, man. Is this what you're trying to do to invoke your treaty rights? Like,
No, that ain't how you approach the whole situation.
right?
First,
This guy,
when you lay out your complaint, you gotta lay out the what you're complaining about. If I got a complaint, if I'm complaining, right, I'm saying that you done something, you violated a breach of trust. I'm spelling out your duties as it relates to cause of action, breach of trust, um, breach of fiduciary duty. I'm laying out the complaining elements that exist so I can identify that. Because we talking about treaty ain't nothing but a contract. So you want to talk about his violation in relationship to the contract. What did the contract tell them they was obligated to do, and what was they in breach of? And you got to lay out the things they in violating and doing wrong in accordance to the contract, which is the treaty. and then you state the facts. You say, hey, on this day, blah blah blah, did this, you know, and you state everything that the trustee had violated, right?
Right. I'm
And
listening.
then
I mean,
and then you going. It's just he's saying a lot of fluff. He's like, y'all are really much. Y'all got me in this corporate war status. Y'all got me under this and under that. But he's not really explaining the violations in accordance to any constitutional merits that he's trying to enforce. And if he's really trying to enforce treaty, then he need to exercise certain things that he should have done over treaty.
right, right.
He
So
should
I
have
mean,
talked about the order. He should have identified the article in which was in violation, all the different articles showing that they were in violation of these articles, and that's what he complaining about.
right. Look, he got the trading with the Enemy Act and may not obtain certain forms of judgment against the plaintiff. The plaintiff requested a plethora of injunctive relief related to preventing defendants from requiring plaintiff to undergo compulsory medical treatment, vaccination, quarantine, and use of protective face masks. Okay, so let's go to the legal standard of this. Okay, the legal standard, y'all, so you can see where he went wrong. It says the federal courts have limited subject matter jurisdiction under the Constitution and federal statutes. Under current statutory schema, federal courts have subject matter jurisdiction over two categories of cases: those that arise under federal law and those in which there is an amount of controversy over $75,000 and the parties have completely diverse citizenship, which is 28 USC 131, 132. Okay. All right. I know you got something to say about this, man. There's, can you make this make sense of that?
Well, this is what they saying. They we only got jurisdiction over the things that what Congress identified that we got jurisdiction over. So he's outside of the scheme or the application of law. He's not mentioning a federal statute. We can't hear nothing but these things. They say these are the criterias. It has to be under a federal statute, and it has to be 75,000 or more. And we
Right.
don't know what the hell because you never identified the particular application of law as it relates to any federal statute that they violated, in which we can identify and say we got jurisdiction, because now we seeing that you utilized that statute to trigger us to say we have the right to hear that. You see what I'm saying? He didn't come out of federal statute. They was trying to see where he was going with this, in which he never identified if it was a constitutional, federal statute, administrative wrong, or common law. He
Okay.
didn't get equal to protection under the common law, or that they failed to give doing administrative process, failed to give him due process, or in accordance to the federal statute, they misappropriated the statute or failed to give due process. Whatever the issue is, it has to be associated with that application of law.
Right. I mean, y'all, due process is a big deal. Like due process usually they get you in the door. So, I haven't heard due process used in any of this motion at all. You know what I mean? So like, so look, so we look at the discussion. So this is the part that get good right here, y'all. So we're talking about the plaintiff alleged there was six sources of subject matter jurisdiction. So he named off the Treaty of Marrakesh, which is usually the Treaty of Peace and Friendship, and then you got um, the 1824 Treaty of Tunis. So then he recites the U.S. Constitution Article 6, and then the U.S. Constitution Article 3. So me and I know you got something to say about this. And then he got the Judiciary Act of 1789, and then the Articles of Confederation, Article what's that, 12. So, all right, let's jump into it, man. What?
Okay, so the issue is Moors think that we're part and parcels to the Constitution, which we're not. See, treaties and how you know that Moors was not a part of the Constitution is they have a signature page. As a signatory, everybody got to sign off on it. And they will sign off on it based upon their status and their name in relationship to their contract. You always have somebody signing off. They're always a signatory. Or you can adopt the treaty. Then the government has to say, okay, based upon the regulations, we're going to adopt this treaty and make it into our own domestic law.
Okay,
So that's the first era. Moors are not part and partial to the Constitution. So the Constitution is not for us to enforce unless we're saying that we're part of that jurisdiction.
okay. So let me ask you this then, because this is going to be the question when we look at number 3 on his um, docket. It says the U.S. Constitution Article, what's that, 6, right? So in Article 6, Section 2, the part of the Constitution that would relate to the treaty in us?
We're not a signatory. You got to remember this. Let's say me and you got a contract, right? And then we have somebody saying they got a contract with you, right? With the same stuff, right? With the same contract we're talking about. They have to sign it. If they don't have a signature page, then they never contracted with you
Okay.
or me.
So, okay. So, what does it say here, though? You say, even after liberally construing plaintiff complaint and considering the preference for allowing a plaintiff an opportunity to amend a complaint, the court will still use sua sponte dismiss the complaint for lack of subject matter jurisdiction. The court cannot liberally construe the complaint to allege a case of action within the court's subject matter jurisdiction. So while the court suspects that plaintiff is attempting to assert federal question jurisdiction, when he referred to the above listed sources, the court will in turn analyze both whether there is federal question jurisdiction or diversity jurisdiction before turning to the propriety of dismissing the case sua sponte. The court will also discuss plaintiff requests to seal the pleadings. All right, so talk about the federal question jurisdiction. So I mean, like these are the things you got to think about when you going in there. What he was doing is he trying to invoke federal question jurisdiction?
He didn't. This is the thing. He didn't know what to do. He didn't know who has original jurisdiction over treaty and who can hear those treaties. So he used a federal question, or he went into a statutory venue under a federal question in which he never identified, right, his rights under contract under federal law, and which would support his right to whatever he's trying to accomplish. So what he did was he just filed a bunch of stuff and threw it all together. He thought he was coherent in what he was presenting, but it didn't. They looking at it like, what is you talking about? You didn't even trigger the jurisdiction with the proper language under a federal statute for even to give us the right to entertain what you talking about.
I got you. So I'm going through it, y'all. Like we don't have time to go through this whole treaty like that because we do got other stuff. But feel free to check out this treaty. But we got to give you the nukes of it. You know what I mean? So it says none of the six sources that the plaintiff cites for federal question jurisdiction confer subject matter jurisdiction over the causes of action in the complaint. So now this is where it gets. See, first, the 1787 Treaty of Marrakesh is no longer in force. Wow. Okay, y'all. Okay, y'all. You hear that? So what you think about what he's saying? Like this, let's stop there because we're told that it's the longest standing treaty in United States history. And we're gonna look at some things that later in a minute that may say why we still believe the treaty is in existence. So what do you got to say about that, my brother? My brother.
In particular, could you phrase the question in a way that I could
Well,
like?
I'm saying, what do you think about that statement that it says that first, the 1787 Treaty of Marrakesh is no longer in force? So could you kind of explain that for people? Because I think a lot of Moors um, are looking at that as cap. That's
Well,
cap.
now the first treaty, it dissolved. It went through a dissolution because it went through a 50-year period, and then they renewed it with the 1836 treaty. So that treaty existed, in which um, they have proof, but it doesn't apply because there was the 1836 treaty that distinguished that old treaty, in which was not into the new treaty's language, that the old treaty would still be applicable to this to this jurisdiction. The language don't express that.
I got you. And they say right here too, like it says that, first the 1787 is no longer in force according to the United States Embassy. While 1787 was the first ratified, it says the treaty was only binding for 50 years. Okay, so that's in the history of the US and Morocco. So y'all understand that that particular treaty is no longer can stand. All right. So, but it says that the Treaty of Marrakesh with the following provision that this treaty shall continue in full force with the help of God for 50 years. So now we're talking about what you said. The 1936 Treaty of Morocco apparently replaced the 1787 treaty after the Treaty of Marrakesh expired. It says that consulates of Morocco, in fact, the United States Department of State does not list the 1787 Treaty of Marrakesh as an active treaty, but the 1836 treaty is listed as a treaty currently in force. Okay, so when we're talking about the treaty, uh, we got to use at least from what I'm getting right here, that if he's going to cite a treaty, it's got to be 1836 and not the 1787, right? Let's see. A treaty no longer in force cannot be considered a treaty in the United States. Okay. So a treaty that has been inactive for more than 180 years cannot create a judicially enforceable cause of action. So he was out the box because he used the wrong treaty, first of all. Now it says that, look, it says that the court recognizes that the 1836 treaty did have similar provisions of the 1787, right? But even if the court liberally construed the complaint to refer to the 1836 treaty rather than the 1787, the 1836 treaty also fails to confer federal question jurisdictions for any plaintiff claims. So, all right, I'm gonna let you go ahead. What you got to say about that, or if you got anything, do you want to keep going? You got you
Um,
on, yeah, you on mute. Yeah, go ahead.
I'm just we have to look at when we're looking at contracts, we have to understand the application and the provisions in the contract to determine what's enforceable and what's not. What's the time period? We have to understand everything in which we give that institution right over us. We must understand how treaties are contracts, and if you're not a party of that contract as a signator, then you're not going to reap the benefits of that contract. And you got to prove, it's called proof of claim, where you have to prove that you're a contractor and that you're a party to the treaty. Am I making
Okay.
sense?
Hey, for anybody, if y'all does that make sense to y'all in the chat? If y'all, uh, if that makes sense to you, comment one. If it doesn't make sense, comment and put a two. All right, that's how we gonna do it because I want to know if y'all understand what's being said. Uh, okay, so I'm just like I'm gonna keep going on for the sake of time because I did want to go to this part because this part right here. So they're saying like a court in the District of New Jersey faced similar claims. Okay, so we talking about another case with Moors. These claims found that the Barbary treaties, which include the 1787 Treaty of Marrakesh, and by extension, the vastly similar 1836 treaty, right, do not provide federal question jurisdictions or jurisdiction to federal court for such claims. So they got C. El Amin Bay versus Stump, which is another case, which we would love to get into probably on the next one of these, right? Because we do know Elamir and them, um, and we do know that they were pushing a lot of treaty argument in court. Okay, so this is saying that it is similar to what this up what the Houston and Houston is doing, and it don't provide federal question jurisdiction. Okay, it say the Barbary treaties aim to eliminate or at least curtail the ill of piracy plaguing the coastal waters and ports of the port of post medieval North African geopolitical bodies and eliminate or at least halt the rise of these fees charged by the rulers of these geopolitical bodies to the then developing American merchantry for keeping peace in the ports and coastal waters subject to their dominion. So, I mean, what it sounds like is they're trying to put it into context that, oh man, they weren't talking about what you talking about. They was talking about piracy going on back in that time. So, I don't know. You go ahead. What do you think about what they're saying? You there? All right. Well, I think King he'll be back in a minute. You come back in. Uh, but I'm just looking at what they're, to me, what their argument is that the stuff that they're trying to say doesn't apply to what was being the treaty was used for. Okay, so like I said, that argument that when we use that treaty got to be real strong, right? But Uh, what does this say? All right, it says after reviewing the 1836 treaty, right? The court agrees that nearly all the provisions deal with maritime and merchant issues and observes that the other provisions appear confined to events occurring in Morocco. So they trying to say that how he was using it, it didn't apply because it wasn't dealing with maritime or merchant issues. Okay, which is like me and Keng talked about before. Like the treaty is basically like a merchant treaty. Okay, it deals in maritime law a lot. Okay, so you got to understand that too. When you got to use maritime, like maritime, I know we talk about the admiralty law and maritime law, but when you're going into a court with federal questioning, they're saying that's not the place to apply that. Okay, so it's also saying that because the plaintiff claims to have nothing to do with wartime or merchant issues near Morocco, the plaintiff cannot rely on the treaty. Okay, so this is what they're doing. If you're trying to use the treaty, you got to understand how they're going to attack that argument. Okay, so look what they say though, because this is what they be saying about when y'all go into court talking crazy, right? Talking crazy. This is what they say. They say for the purpose of a civil suit, raising claims based on the events that occurred within what is the United States geographical territory is factually frivolous. And so that word frivolous, I'm gonna tell you, they use that word to describe a lot of what how they look at a lot of the Moorish legal paperwork that comes through their doors. So one thing is, as Moors, we really got to tighten up our legal game. We got to go in there with our game high, right? If we're going to prove something to them, because basically you got to prove that this is dealing with merchant, right? So hey, Ken, you there? You there, bro? I'm just trying to see if Ken fell off of the earth or something, right? Let's get into this though. We're gonna finish this up. So, all right. So a lot of people, as for the 1824 treaty that he was talking about, he was like the United States Department does not list the treaty as enforced. So when we look at that treaty, a lot of times when we talk about treaties, we think that a lot of times we think treaties just always are continual, like they're still in force. Like once they've been laid down, that they will be there. But what they're telling you is right here is that the treaties, if they're not enforced, then they can't be used. So a lot of these treaties that are Barbary treaties, you got to check to make sure that they're still in force. It says that the Treaty of Tunis is another of the Barbary treaties and amendments to the earlier treaty of the 1790s. Okay, when you look at the Avalon Project, the Barbary treaties, there was a lot of Barbary treaties that was going on. Okay, so a review of the document reveals that the 1836 Treaty of Morocco and many of the Barbary Treaty most provisions deal with wartime and merchant issues. The provisions that do not deal with maritime or merchant issues appear to only apply to Tunisians. So plaintiff does not allege to be a Tunisian. So that's another thing. He's using certain treaties that he's not claiming to be a party of. He's just throwing out treaties to, try to make a point. Okay. So it says that the court is unaware of the plaintiff who proceeded under the subject matter jurisdiction of Barbary treaties. So then it talks about Article 6 of the Constitution does not confer subject matter jurisdiction. Okay? So when we talk about Article 6, a lot of times we talk about Article 6, Section 2, which applies to saying the treaty is the supreme law of the land. We should call that the treaty supremacy law or whatnot. But that they're about to break that down now. The first clause of Article 6, I should say, relates to whether debts entered into before the Constitution's ratification is valid. So right here, he cites the right article, but he doesn't seem like he used the Article 2 provision. And I'm gonna tell you, like, you got to be clear when you're dealing with court. You got to be clear on what you're saying. You can't be general. It leaves too much for interpretation. And it says that the complaint has no allegations concerning debt. So they was like, okay, well, you only Article 6, you talking about doesn't apply. So now they're talking about the second part of the clause, which is the supremacy clause. Okay, it says which has to do with the place of federal and state law under the Constitution. It says that the complaint never alleged conflicts between the federal and state law. So the supremacy clause cannot be conferred federal questions for the complaint. Ugh. They killing him. They killing it. You understand what I'm saying? They are going in on the dude. They're trying to say that he did not invoke uh, the proper conflict. If you're going to use the supremacy clause, then they're saying that the complaint has never alleged conflict between federal and state law. Okay. So when you trying to deal this treaty, you're going to have to apply uh, some kind of conflict between federal law or the state law. So, uh, like I said, I don't want to go all. I just want y'all to see why some of this is going down like this, like why we not using these treaties properly. We gotta study the failed attempts of the treaty, okay, in order to use the treaty in here properly. Because I think a lot of times we just think if we throw it in there that it's an argument, but you see how they argue. You see how they arguing against this, okay? They going in on them. I don't even go through all this, but you got to understand the federal questions. It says beyond the sources of federal question jurisdiction raised by the plaintiff, there are likely no sources of federal question jurisdiction available for the plaintiff for most of the claim. Okay? It says determine that the plaintiff is a sovereign citizen and thus free of compulsion under federal or state statutes or ordinance. And the court believed that most of the plaintiff claims having to do with guardian relationships or estates, while still frivolous, are within the realm of probate law. Okay? So it says the judicial procedure by which a testamentary document is established to be a valid will. So I'm going to tell you something. They're trying to tell you right here that if he had some type of will and testament, okay, which is part of his estate, which is what he was trying to sue in the first place, was trying to sue his estate. If his estate had like in none of this document does it show that the plaintiff had his estate in order. Did he have his will, testament? Did he have his estate? Did he have any estate planning? Or was he just going in there based off of a lot of talk? Okay. So, all right. So let me go further into this, man. Like I said, y'all gonna have to go and check out the actual and read the whole script, right? Because it goes through a lot. We talk about that. Let's look at diversity citizenship. A lot of times when we're talking about USC, I thought diversity of citizenship was a 1984 USC, but nonetheless, it says diversity jurisdiction. As discussed above, the current statutory scheme for diversity jurisdiction requires that the parties have diverse citizenship and that the amount of controversy exceeds 75,000. Diversity of citizenship must be complete, meaning that each defendant is a citizen of a different state from each plaintiff. When determining citizenship of the parties for purpose of diversity jurisdiction, the domicile of each party is used. I love it that they use the term domicile. They didn't use the term residence. Okay. Domicile involves two elements: the physical presence in a state and intent to remain in the state. And so it says, while the plaintiff claims that he is not a citizen of the United States, he listed an address. Aha, as they say. Aha, aha. Look, it says that while the plaintiff claims that he is not a citizen of the United States, he listed an address in Lake Orion, Michigan, under his signature. So, okay, so it's important that your domicile, if you're going to claim that you're not a U.S. citizen, your domicile should not be in the United States of America. Okay. It says that the address under the plaintiff's signature is sufficient evidence for the court to believe that plaintiff has a physical presence in Michigan and an intent to remain in Michigan. Okay? So, Homeboy went in there, a regular U.S. 14th Amendment Negro, but tried to use party uh, treaty stuff, right? And was knocked down. Period. Okay? So, conclusion. So, it was dismissed, okay? Conclusion. Wherefore the order is that the complaint is dismissed. Okay, so understand that what you know as far as jurisdiction and how you're trying to comply it in court is not, you can't, that's not it. You can't just write up some stuff and expect the court to go for it, right? All right, because when you're using this treaty, like I think Brother King is gone for the night. Yeah, he gone for the night. But what what we're looking at is the other part of this is the Treaty of Peace and Friendship, or is Morocco's relationship with America on the same ground or standing that it was back in the 1800s? Okay, because we're talking about 2023 and trying to apply treaty law to something that is not even the same, right? So one of the arguments that me and Brother King would have is that Morocco is not the same entity that it was back in 1787. And so therefore, what is the relationship of the treaty with this kingdom of Morocco versus the old ancient powers of the empire of Morocco? Okay, so I think that there's some type of correlating effect to it. First, let's look at when is the empire ended? Did anybody know that the empire of Morocco no longer exists? Did y'all know that? Do we know that? Okay, let's look at this. Let's look at it. All right. So we got let's see, where is it? The birth of the Moroccan Empire. Okay, let's look at this. I want y'all to look at this. We're gonna look at this real quick. Let me pull that screen up. Let me pull that screen up. Okay. So I'm gonna share this screen again. Let me go to it. I like doing it this way so I can see what's going on without having to have my whole screen sharing. Okay. All right. So now let's look at this. Right. Let's look at this. Boom. Y'all see it? We're talking about the birth of the Moroccan Empire. Okay. So the Moroccan Empire was one of the most important empires in the Mediterranean region. Okay. we're not going to read all this, but I want to give you a glimpse of what they're saying. It's saying that it had influential roles in the history of Europe and look, Western Africa. Okay, so the Moroccan Empire played an important part in Western Africa. If we know anything, we know that we know that we were a lot of Americans melanated that were here before the European. So we're not arguing about the melanated influence in America. But what we're also saying is that a lot of Africans came over here too, right? Not as many as they're saying, but we do know that there were groups of Africans coming over here. And uh, a lot of them that came to the United States, as we know it, came from Western Africa. And so the importance of Morocco in Western Africa around that time can't be taken away. Okay, but let's look at the date. It says that the date in which the empire started is subject to some debate, but we could say generally it's accepted among scholars that by 788 BCE, I mean Common Era, so CE, 788 CE or AD, okay, it has already started. And then it says that it officially was abolished in what? 1957. So it says that it existed for 1,169 years. Okay. And it says that the current country of Morocco, unlike what Turkey is to the Ottoman Empire, it says is its continuation under a new form since it retains many of its institutions, traditions, etc. It says just in a reformed or modernized fashion. Okay, so what I gather from that, y'all, is that Morocco Empire ended in 1957, but it still remains remnants of it today in the Kingdom of Morocco, and that there is some relationship with the United States and Morocco. Now, is that relationship the exact same as it was under the empire? I don't I don't know. That's what we're going to look at because there are things that's going to show you that America may not look at Morocco the same and that may have jeopardized how the treaty can be used. Okay. One thing that we read that's important is that it says in 1957, right? In 1957, Morocco was no longer an empire. Now, what I'm about to show you here is important because it may explain why certain things happen in the United States when the empire fell. Okay, so let's look at right here. We're going to look at it talks about this is what's this the end of American consular jurisdiction in Morocco. So there was a consular jurisdiction. There was Morocco under the Empire of Morocco. There was a consular court in the United States as well. Okay. So let's look at this, man. Let's look at this. It says the end of the American consular jurisdiction in Morocco. It says that the relinquishment by the United States on October 6, 1956, of its consular jurisdiction in Morocco marks several respects to an end of an era. Not only did the action specifically terminate privileges in the Sharifian Empire, so now let's look at this because they use the term Sharifian Empire. So when the brother was doing his court papers, and he used that term, Sharifian. This right here is saying that this ends and terminates the privileges in the Sharifian Empire. So there were certain privileges that no longer exist now. Okay, it says with which the United States has enjoyed in varying measure for 170 years, and steps taken had also a wider distinguished in American law an institution of consular jurisdiction in its classic form. So the United States stopped looking at consular jurisdiction in regards to Morocco in 1956. All right. I'm not sure why this is not showing up like that. Um, Let me put this back up again. I don't know what happened, y'all, to the page, but we're about to pull it back up so that you guys can see it. I don't know why it blurred up on me. You know how these computers are. They be tripping. They be tripping. So let's go back, y'all. Because this is heavy, man. This is for all us Moors, man. This is, I mean, for real. Like, you are Moor or, you studying all this Moorish science like we've been doing. It's important to understand what the hell is going on because we throwing stuff in courts that is kind of archaic, not really understanding the history behind what's going on. Okay, so like I said, let's look at this real quick. Like I said, let's look at it one more time. I'm gonna let you look at it. I read about it, but it just says that the privileges of Sharifian Empire that had been enjoyed for 170 years is gone. Okay, American jurisdiction in Morocco in recent years rested in the first instance of the look of the Moroccan American Treaty 1836. Okay, so this right here is talking about the treaty that the brother had in the case. So it's saying that um, which is substantially similar to the original treaty, which we know. The basic grant was supplemented by rights secured by two multilateral conventions relating to Morocco, okay, to which the United States was a party. So we had the Convention of Madrid in 1880, which brother never mentioned or talked about. And then it said the General Act of the Algeciras of April of 1906. Former American claims to a still wider jurisdiction based on custom and usage, and through a most favored nation clause in the American treaties, which other states which were no longer in force were declared unattainable in proceedings before the International Court of Justice in 1952. Now, I will say this: there is a court case that we talk about, and there's some other Moors that talk about this court case. It was a French sued the United States about Morocco in 1952, and they won that case against the United States, which is a good case for us to get into. Um, because it's an important case to look at as far as United States Moroccan relations. Okay, but it says right here that as one results in the proceedings, American jurisdiction in Morocco after 1952 was confined in practice to cases between Americans. Okay, the original grant made in the 1836 treaty says although the theoretical jurisdiction under the Act of Algeciras and the Convention of Madrid was somewhat more extensive. Okay, in the Tajir zone, the United States not only maintained its own territorial jurisdiction, but also from 1953 onwards participated in a mixed judicial system established there. Okay, so will the trend of events in Morocco pointing definitely to its complete independence or immediate future? Now, let me explain something right now. There was a time when the United when Morocco lost its sovereignty under French. So I want to say in 1957 the French was given back their sovereignty, and so when that happened, you'll see that the United States continued their relationship with them. Okay, so let me okay. So let's keep going. Let's keep at this because I want y'all to understand this relationship with the United States. Let's look at it. Let's keep going. I'm gonna show you another screen. Okay, um, we're going to look at the United States relations according to their interpretation. So we're going to look at the United States relations on as a Department of State. So it's saying right here, Morocco was one of the first countries to recognize the newly independent United States. So right here, they're telling you right here, for us Moors that know that, they're telling you that Morocco was the first treaty recognized by the United States. Okay, by the Sultan. Okay, Morocco and the United States share common concerns closely to security, political, economic issues, sustainable development, and the United States designated Morocco a major non-NATO ally in 2004. And the U.S. Moroccan militaries hold joint exercises and training. So Morocco is a strong partner in counterterrorism. So there is this strong relationship that the United States has even today with Morocco. The United States assists Morocco in a lot of ways. Okay, they are here to promote for terrorism. Um, they are giving them things. The United States is aiding in the Middle East and the United States. I mean, and Morocco. They're giving Morocco certain things. So right here it says that there's going to be promote security, prevent acts of terrorism while addressing the core drivers of instability, such as political and social marginalization. The U.S. education and economic growth assistance aim to improve productivity and access in economic opportunity. Our support has a positive impact beyond Morocco borders in both the Middle East and Africa, bolstering Morocco's emergence as a major partner in regional stabilization effort. So Morocco and the United States do have a strong relationship, but this is not saying that they got the same relationship that they had when the treaty was first established. Um, I'm trying to see something. There is more to this. Okay, so let me go here to the birth. Because basically, the United States at some point recognized after um, after France gave back, or after Morocco gained their independence from France in 1957. Um, the United States says that they did recognize the Sultan again, and they recognized Morocco. But Morocco at this point was a kingdom. Okay, so it was no longer the Empire of Morocco. The treaty is under the Empire of Morocco and not the kingdom. So there's not the same understanding or relationship that the kingdom has with the empire. Okay, or not. What I'm saying is that the Moroccan kingdom doesn't have the same relationship with the United States as it did under the Empire of Morocco. And even with me studying this more and more, because I mean I got videos where we talk about the Treaty of Peace and Friendship, and its provisions. And even at that point, I didn't understand the historical elements that have changed how the treaty is perceived by the United States and how to use it. Okay, so um, hopefully we'll get more into that part later. Like I need Brother King to get back on the line so that he can break down some of this, because that was some of our argument, was that the treaty now is not the same under the kingdom of Morocco. Okay, so basically these are some things that we need to think about, y'all. And I appreciate you coming on and listening. Like I said, I hope y'all like the video. Please subscribe and hit the notification bell so that you can receive more of these videos when they come on. Because we're going to do a part 2 to this, right? And there's another case law that we want to get into. So I hope next time we're gonna get on. I think it was too late. My brother King Obey was too late for him. He's an early bird. So we did get in here late, y'all. So but I hope appreciate y'all checking out this video, and we're gonna get back to you. So peace and love. Tutanana.